Thank you, Mr. Chairman, Madam Ranking Member, distinguished members of the panel. May I start with a point of personal privilege and say, as a Williams College alumnus and former trustee, I am proud to be sitting next to what my college is now producing. Members of the committee, the challenges of free expression on our campuses have never seemed greater. I know this from my years as a law school dean and as a university president, that these challenges come in all directions and from all contexts. They come from the left and they come from the right. They involve students, they involve faculty, they involve outside speakers, as Mr. Wood has just talked about. Given the coarsening of our public discourse and the lack of clarity about our core value of free expression, it's perhaps no surprise that this issue now presents itself with such urgency on our campuses, public and private, small liberal arts colleges, and large research universities. So at this moment, it is particularly important that we recommit ourselves to first principles, and this hearing is a welcome opportunity to begin to do so. The ranking member poignantly talked of the context of large universities, and perhaps as the only person sitting in this room who has been a university president, I'm grateful for someone understanding the complexities of that role. It is precisely at times that university presidents face, like these we're talking about, that first principles are essential. And let me restate three. First, as each of you has mentioned, robust free expression and free inquiry are central to the mission of our colleges and universities. Second, the limits of such expression, which should be all the way at the margins of expressive activity, should turn on the intent of the actor and not on some crude attempt on our part to distinguish speech from conduct. An intent to threaten, an intent to intimidate is different from an intent to express, an intent to communicate. And third, there is an obligation, indeed, as Senator Cruz said, a moral obligation, in my view, to respond to hateful speech, not to suppress it, but to respond clearly and forcefully. Universities and colleges in this country have a mission, I would say a sacred mission, to create and discover knowledge and transmit that knowledge through our teaching and our scholarship. So it should go without saying that robust free expression is central to that. As a result, speakers are presumed to be permitted to speak and should expect to face questions and answers. Students, and to give answers. Students and faculty are presumed to have their writing and their speaking protected. So is there a limit to this expression? When does it cross over from protected expression into something that would be prohibited, or in a campus context, into a context where sanctions would be appropriate? As I said, I believe this turns on the intent of the actor. Let me give a different example from Williams College, and this is with the prior president of Williams College, although, Mr. Chairman, that prior president is now the president of Northwestern University, so he does seem to keep coming up in this discussion. When I was a trustee at Williams, there was an event in which a student had on her door, the leader of the Jewish student group at Williams, on her door, posted a flyer that said she should evacuate her room immediately, and this was meant as a faux eviction notice to parody what has happened in Israel with Palestinian homes in the Israeli Defense Force. The president of the college called me up and said, "Is there something we can do about this?" And I said, "We need to know what is in the mind of the student who did this." He said, "How would we possibly know that?" I said, "Well, why don't we find out how those flyers were distributed? Was it just put on one student's door in an attempt to threaten or intimidate her? Or, as turned out to be the case, were they put on the doors of every one of the doors in that dorm? In which case, in my view and in his, it was an attempt to demonstrate a strongly held political view, offensive to some, disagreeable to many, but nonetheless one that should be protected. And therefore, the speech was protected. No conduct should be taken. No action should be taken for that conduct. But what of speech that is protected that is particularly hateful? Here I go back to something that Senator Cruz said at the beginning. I believe Justice Brandeis had it right when he said the answer is not enforced silence, but more speech. But more speech is not merely an option in the time in which we're living. It is an obligation. And so a university president has an obligation to speak out in the face of hateful speech, not to repress it, but to speak out. A wise president will be very careful not to be calling First Amendment balls and strikes on a daily basis. that debases the currency of the presidency, and it oversteps the boundaries. But if a wise president picks her or his moment to say, this kind of conduct, this kind of expression is not representative of the best values of this college, the best values of this university, then that holds us to the highest levels of what our colleges and our universities are about. Not merely to educate, but to provide the citizenry that is the essence of an engaged democracy. Thank you, Mr. Chairman. I think that Floyd has got it right, that the presumption is in favor of speech. The question is, when can you overcome that presumption? You certainly have situations on campuses now, and particularly in concealed carry jurisdictions, as you say, where this becomes an enormous concern for the university administration. And there have been cases, most of the time this information is not made public, where the university president, these are people I've spoken with, have been informed by their own campus security that we have credible information from local law enforcement that there could be people with weapons on campus. I appreciate the analogy to the heckler's veto, but the heckler's veto cases come out of the 1960s and in southern jurisdictions that wanted to repress civil rights marches, and the answer there is they simply have to make sure there's enough of a police presence. You can't just tell a public safety office in a university, you've got to just beef up. Sometimes you just don't have those resources. So those are the kinds of judgments that a president of a university is required to make on a daily basis. As the one person in this room who's actually had to make these kinds of decisions, we are in the business of educating at a university, but we don't have the resources of a town, of a city at our disposal, either literally a budget to call upon or a city to turn to say, you need to take this one over right now. So these are always judgment calls that are made. I think the way to start with this is with a strong presumption in favor of the speech, particularly if it's speech that's coming from a student group who's invited somebody. If an outside group wishes to come to campus, that's a different set of issues, certainly for a private university, to a certain extent even for a public university. But always then a judgment call to try to find a way to get to yes on a speech. Perhaps you even have to have it closed and have it available for closed circuit. There are a lot of ways in which the university can think about this. But the suggestion to universities, and it's not just public universities, private universities that are resource constrained as well, that we have the resources to throw at all of these problems is a vastly exaggerated notion of what universities can do. It's putting more at the university's doorstep. So I think if you start with the presumption in favor of finding a way to get to the program, and only if that can be overcome, then you don't have a program on campus.
No matter how radical, offensive, biased, prejudiced, fascist the program is, you should find a way to accommodate it.
What I would say in response to that, Senator Feinstein, is that if we're talking about the substance of the program, not the danger and credible threats, but the substance of the program, then yes, then I do think that the program, if a student group invites, then they should be able to. However, I would say a flat rule of mine was if a speaker comes to campus, he or she better be prepared to answer questions. And what I would tell supporters, donors, alumni who would say, how can you have so-and-so speak on campus? I would say, trust my kids. Trust my kids to ask them hard questions, to ask them pointed questions. That's how we'll get to the truth.
But here's the problem. It very often isn't your kids that are the problem. It's outsiders who come with a specific program to disturb and hurt. Candidly.
Well, then you're quite right. And then with a private university, you do have the option of saying this is an event that is closed to university students. Members of the university community are invited, and only members of the university community are invited. Our obligation is to educate.
Public university?
Public university obviously has a much more significant problem there, and I would be deferential to the Chancellor of Berkeley or the President of the University of California to have to make a very tough judgment call, particularly in the cases that you were describing.
Which, well, I might say, are more real than I think a hopeful audience might think. And I think that's a problem. And I think particularly in view of the divisions within this nation at this time, which are extraordinary from my experience, I think we all have to protect the general welfare too. And I appreciate free speech. You know, those of us that run for office, we run for office on the basis of being able to speak freely. But it's another thing to agitate. It's another thing to foment. And it's another thing to attack.
I think in many of these speeches, and it is one of the things that a president would take into account, if a speaker is coming to campus for the purpose of agitating, cases of speakers who post images of students on screens in order to intimidate or humiliate those students, that has no place on a university campus. That's not an intent to communicate, that's an intent to intimidate.
Thank you. Appreciate it. Thank you.
I would say there are two different questions here. I think Mr. Wood has put it exactly right for what a student group would do well to use as the standard. As a former university president, I would say my standard has to be, ironically, somewhat lower than that, which is to say that would be my standard for somebody I, as the administration, would bring. But for somebody who a student group might bring, then the question is this going to be threatening to campus, in which case it could be restricted, but otherwise, no. If a student group wants to put on an event, a student group can put on an event with one very powerful stipulation. Any speaker who comes to campus has to be prepared to stay and take questions and give respectful, decent, civil answers.
Mr. Lawrence, you were talking about how you balance this and what the standards should be. And like you, I really value the First Amendment. Thank you, Mr. Abrams. My dad, maybe I wouldn't be here. My dad was a reporter his entire life. He's now 89 and blogs still from time to time. So, Mr. Lawrence, you want to talk about that value of free speech and how important it is. And you were answering more in response to Mr. Wood. I appreciate it about those when it's appropriate to restrict speech. You want to go through that one more time just from your view, and then I'll ask a few others that question.
Sure. I think we start with the presumption that free speech is protected on campus because it's absolutely central to the function of creating knowledge, discovering knowledge, and transmitting that knowledge through our teaching, our scholarship, and the discussions that take place on campus. So the lines are drawn only at the extreme edges. The extreme edges meaning that which threatens, that which actually would disable the learning process, not that which makes somebody uncomfortable. Look, part of the function of spending 4 years in an undergraduate institution is to be intellectually uncomfortable from time to time, to have your ideas challenged.
Yes.
That's different.
I agree. I went to University of Chicago Law School.
Well, then nothing more need be said. Chicago, I'm told, is the one place where it was said you could flunk lunch.
Thank you. I didn't do that, but thank you. Thank you. Okay.
Actually, that's the faculty, not the students, who could flunk lunch. So that with those exceptions, speech will be protected. That's the essence of the institution.
Right. And this idea that Mr. Wood had just brought up, which I appreciate, the kind of the threat. If someone has made a threat, which I'll get to you maybe, Mr. Cohen, would you judge that by in the past or recently? How do you do that to figure out if it's
As near as you can assess, what you're trying to do is to figure out what is the intent of the actor at this time. So if you have someone who is communicating views that are even unpleasant views, even I would say hateful views, if the intent is to communicate those views, then that is protected. If the intent is to threaten or to intimidate or to menace, then it's not. It's not always an easy line to draw, of course, but those are the lines that we're drawing all the time in the criminal law, and on campus, those are the lines that administrators are trying to draw all the time.